This isn't just another DUI hearing. This is a case where decades of past offenses collide with a dangerous present reality. A Navy veteran with a long history of alcohol-related driving charges is back in court after yet another incident, this time involving a crash. The prosecution is raising serious concerns about public safety, while the defense is asking for compassion, treatment, and a second chance. But the judge is caught between two responsibilities: helping someone battle addiction and protecting the public from potential tragedy. So the real question is, how many chances is too many?
With 10%. I think that I'm asking the court to review that for an abuse of discretion. This is the defendant's 11th or 12th OWI. So we can see his priors are from 2020, 2018. There were two in 2012, 2005, 1995, 1993, 1992, 1989, 1988, and 1986. And specifically, he got for OWI.
What year?
2022. The concern for people is released to the public of the defendant. Professor stays on the scrum cutter and there's been no indications that he's violated. That was right corrections this morning. But this pervasive and ongoing history of OWI is of extreme concern to the people, the safety of the public.
Here's where the weight of the past really hits. The prosecution lays out a long timeline of prior offenses stretching back decades. This isn't an isolated mistake. It's a pattern of behavior. And in court, patterns matter. They tell the judge whether someone is likely to reoffend and whether the public is at risk. Even more concerning is the fact that the defendant had already served prison time for similar conduct and is now back again just a couple of years later. That's why the prosecution is emphasizing community safety over leniency. So ask yourself, at what point does rehabilitation take a backseat to protection of others?
Challenge inpatient treatment program. It is Christian-based, and he let me know
How
that.
come he isn't in an inpatient treatment program now?
Well, Your Honor, he has been going to AA meetings, and it's an up and down battle with Mr. Radke. And
I understand that, but I also understand that he served prison time for drunk driving. Was released in 2022. And by 2024, I'm back here again with this. Right?
yeah, that's correct, Your Honor.
What was the alleged BAC in this matter?
Yeah, that's a really good question. We're still awaiting the blood results. This was a single vehicle crash that occurred. The defendant.
There was an accident?
Yeah, he crashed, a single vehicle crash. And the
Mr.
defendant
Allen.
released all field sobriety tests, all PBTs, and the blood, as the blood draw as well, and we did get a warrant. So we're still waiting on that, but we did charge the case given the history. And I will let the court know too, that at the time that the defendant was booked into the Washtenaw County Jail while awaiting medical examination, he did submit to a PBT at the jail, which was a 0.147.
That was at the time, 147 at the time of booking?
At booking, that's right, Your Honor. But of course, the court knows we won't be able to use that number for our case, but that was the PBT at the time of booking.
Anything else, counsel?
Your Honor, Mr. Radke was arraigned in front of the Honorable Magistrate Fink. I believe she appropriately set the bond here at $50,000, 10%, with a scram tether, with a no drinking, no driving standard bond conditions. Yes, there was an accident. Nobody was physically injured. He has been on scram.
We had a blessing.
He had a blessing, but nobody, from what the alleged report says, nobody was injured. He checked in today early at community corrections. His agent is Mr. Levitt. They downloaded they gave him a main base device for his home so he can continually test at home. He has had no issues since he's been arraigned. He is compliant with all of the bond conditions here. And he's
Counsel,
here.
you say that to me, but we're a week out from arraignment. It's a week.
I know, Your Honor, but I'm just trying to.
No, go ahead. You make your argument.
Yeah, I'm just trying to let the court know that, Magistrate Fink heard both arguments. I believe she set the bond at an appropriate bond. If Mr. Radke would have known that the bond would be raised, he would have never posted a $5,000 bond that he had to use on his credit card. His son, he had to call his son here. His son is in the courtroom now, trying to take care of these matters. I'm just asking this court if it would have any leniency for Mr. Radke to allow him to continue to do what he's been doing and get these matters taken care of here.
I believe that given the defendant's record.
This is a turning point. The judge makes it clear this decision is not about punishment. It's about risk management. Even though the defense argues that the defendant is attending AA meetings and trying to improve, the court isn't convinced that's enough, especially given the recent crash and the history behind it. So the bond is increased to a $50,000 cash surety, removing the easier 10% option. That's a major shift. It means the defendant either pays the full amount or stays in custody. But then comes an unexpected twist. The judge offers a path forward. Treatment over detention, if handled correctly. So now the question becomes, is this strict justice or a second chance in disguise?
But what he's doing right now gives the court serious concerns or pause. I don't believe that the magistrate in setting the bond, I think that there has been an abuse of discretion. I'm going to set the defendant's bond in the amount of $50,000 cash or surety bond, no 10%. I will, however, do this. Make a decision. You said that the money was paid on a credit card of some kind. I don't have a problem refunding the bond that he's paid if he needs those funds to pay for inpatient treatment. So he can be released to inpatient treatment. I'm phrasing it that I'll consider release to inpatient treatment. I'm not saying on a PR at this point. But if he needs those funds and you let us know that he needs those funds to get himself into inpatient treatment, I'm not going to have a problem with that. I want him to have help. I want him to not deal with I want him to be able to deal with the demons that face him. And I don't want him here on an OWI causing death. And I think that I need to protect the community, and that's how I'm going to do it.
Okay, Your Honor. Can I ask to approach, please?
You may.
Thank you.
All right, record should reflect that we had a bench conference just in terms of the details. And again, so that I'm very clear on the record, I don't have a problem refunding.
In the end, the judge strikes a careful balance. He refuses to lower the seriousness of the situation, keeping the high bond in place, but also opens a door for something more constructive, inpatient treatment. By allowing the bond money to be refunded specifically for rehab, the court is sending a powerful message. Accountability and recovery can go hand in hand. This case highlights a bigger issue in the justice system. How do you handle repeat offenders struggling with addiction while still protecting the public? So what do you think? Did the judge make the right call by prioritizing treatment, or should he have taken a stricter stance? If you found this case as powerful as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom breakdowns that reveal how justice is actually served.